Hello, Fam. It's so good to be back here. I have missed you so much. I hope you have missed me as much as I have missed you. So, as always, my name's Fortunate Ingabire if you've not been here before, but I like to go by the initials Fam, R from my family of origin, and M from my family of choice. And today is a special day because I have somebody with me. But before I introduce them to you, I wanted to just once again, thank you for sticking by me and visiting this page every so often, and I hope and pray that you have found it helpful. So today my visitor is none other than Council Hudson Katumba, and over and above being a great attorney, he shares a lot of insights on so many things. So I'll let him say something.
Welcome to the viewers, and thank you for always tuning into the page or the platform where she does upload the content. And I'm looking forward to sharing a few insights about the subjects we intend to talk about today.
Thank you, Hudson. So as you all know, on this page I share about healing, mentorship, and life generally, and healing beyond loss. I also like to share things that will lead us on our path of healing. So today specifically I wanted us to talk about estate planning, but specifically will writing. And this is from a personal experience of somebody really, really close to me. In 2021, we lost a loved one in our family. And unfortunately, at the time they passed away, we couldn't find their will. So there are very many dynamics around the issue. And eventually when it came to putting him to rest, there was also a bit of court squabbles and conflicts because there was no clarity on where he should be laid to rest. And so eventually the matter ended up in court, and it took, I think, about over a month or thereabout before we could lay him to rest. And that conversation carried on for a while, and I thought it was very important for me to come back here and engage Hudson to share with us tips or even what he thinks about will writing. So Hudson, I'd like to kindly share with us and the viewers especially what a will is, what should be in a will, who should know you have a will, and where the will should be.
A very, very critical subject that is overlooked in the African setting. There is a belief which has no foundation whatsoever that writing a will is setting yourself on a course of death. I need to state categorically that writing a will is getting your affairs in order before you breathe your last. It's very important because a will is the document plainly that projects your wishes on how you want your estate or your property to be simpler in my expression, how you want your affairs to be run when you're not here tomorrow. So it is very important for you to reduce your wishes into a document. Now that document is called a will. You must know that a will takes effect, most importantly, upon your demise, upon your death. It's a document that you should entrust with people you trust. For example, your attorney, or a professional that looks at your financials, or a confidant that you know will bring it forth at the right time. Now, a will is a simple document, but it has specific requirements under the law on how it should be crafted. So not every document where you state your wishes will qualify as a will. In fact, it will be very unfortunate for you to write something that does not pass the test of a will. And you must note that your will should be in writing.
Okay.
It has to be reduced into writing. It has to be dated because the date is the point of reference when we're looking at its validity. It must state the particulars of the person making it, your name, your age, and the details, your biodata. It should state your properties, if you have land, if you have chattels, if you have equities, if you have insurance policies, anything you have earned or created or bought or acquired, even if it's a car, it should be reflected in your will. It should also state the people that you want to benefit from what. It could be in percentages, it could be specific that I leave this land for my daughter, for my cousin, for my mother. You should state their names in full, their ages. If they are minors, state so. If they are not, state so. It should be signed by the person making it, because without a signature, it will be invalid. It should be attested to, what we would call simply witnessing, by two competent witnesses who should be with you when you are signing it off. So by and large, that document should be dated. It should have the particulars of the beneficiaries. It should spell out your properties. You should actually appoint executors in that document, the people that you want to execute your will upon demise. It should be signed by the testator, the person making the will, and it should be attested by two witnesses.
Okay, thank you very much, Hudson. That's very insightful. Maybe if you could just dig deep and tell us what you mean by competent witness.
I don't want you to use your brother who has just been at the bar and taken alcohol to come and witness your document, because they might not even remember that they did attest it. So it comes out and someone says, that is not my signature. In the absence of that signature, then your will is rendered invalid. So competent in that sense is a person who is sober, of sound mind, of majority age. You can't have a child witness the document. You can't have a beneficiary under the will witness or attest to the instrument, because then there's a conflict of interest or things like that might crop up during the execution or enforcement.
Okay,
of the
thank
will.
you. So let's talk husband and wife. Should my husband know that I have written a will?
They don't have to know.
But is it okay for them to know?
I would say yes. I would also say no. If you're a beneficiary under my will, I don't want to tell you that I have created a will and possibly you are a beneficiary under the will, for obvious reasons. You could tempt someone to end your life earlier. It has happened. On record, we've read cases where a person knew that they were beneficiaries under a testamentary instrument and they took out the other person.
You rush there.
Yeah, so it is safe to just secretly prepare your will, place it in the hands of very trusted confidant or your attorney, such that at the right time, when you've passed on, they can bring it forth, and then the rest are details. Okay,
thank you very much, Hudson. I really appreciate you taking time to share. And dear viewers, you've heard it from an experienced attorney. So if you have not yet prepared your will, please do contact your lawyer. And if you do not have a lawyer, we might have some recommendations for you, so feel free to reach out. But most importantly, as always, there is something that happens when you lose a loved one. And unfortunately, there is never a guarantee that the things we leave behind will be taken care of as much as we would have wanted to take care of them. But even with that knowledge, it's important for us to make sure that when we leave our affairs right, just to make sure that we do not create more chaos for the people that we've left behind. So it is both for your good and for the good of those that you leave behind. And like I always share, I wish you a lot of healing. I wish you a lot of peace and joy, and especially now as you think about the things that you might want to put in your last will and testament. And of course, if you have any other questions for the attorney, or if you need any clarifications, please feel free to leave them in the comment section. And if you can't do that, please feel free to reach out to me on the email in the description.